All right, next up is the Siasconset, that sounds weird, Siasconset Beach Preservation Fund. Request for assent to seek notice of intent from Conservation Commission for expansion of erosion control project with use of town property. So we decided in executive session to bring this to the public in open session. We have talked about this 5 different times in 2018 in executive session, and we felt that got to the point where we needed to bring it to the public for a couple different reasons. To give an update of where we are as much as we can, to hear from the public, and to see if we are ready to take a vote on the assent for the NOI for it to go to the Conservation Commission. I know there's a lot of passion and maybe anger and interest on this subject. I just want to make sure that we continue to be professional and stay passionate to be professional and considerate of everyone tonight. If there's any questions for any other members, try to put it through the chair. Tonight, I'd like to want to hear from the public, and I would like to give maybe 15 to 20 minutes, try to get people to talk short, 2 to 3 minute spurts. If needs to be another question or a rebuttal from when the board is speaking, I'll allow that, but I just want to make sure that it's a lot of us could talk about this for 60 minutes minimum at the microphone. So I want to try to keep it short so everybody who is here we can get as many people as we can to speak. I want to be clear though, this is not about licensing. Anybody who's listening to this on the radio, we are here to talk about to possibly take a vote or not on the notice of intent to allow SBPF to go to the Conservation Commission. I just want to try to be very clear on what we're here to talk about. Would the board like to make any comments?
I just wanted to further clarify, because I think we did end our last meeting with a sense of wanting the conversation to be public and for there to be as much transparency as possible. That part of it's sort of nuanced. It's the conversation about there's certain, based on the last memorandum of understanding, there's certain contractual obligations that haven't been met, and whether we would even consider discussing the NOI without those obligations being fulfilled. And I think both sides were a little caught off guard by the timing and the time frame of needed to fulfill those obligations. But I just wanted to clarify, for me, it was whether we would consider even discussing the NOI without those prior obligations fulfilled. And I think it is a common theme that has come up a couple times tonight already. Yeah. And, I don't think that, well, I'll let everyone else speak. I just think it's something, it has been an issue, a common issue.
Yeah, we'd heard clearly from town council that were some obligations by SPVF that had not been completed, and there had been negotiations back and forth. There had been, cabinet meetings or staff meetings with representatives, and there was an outline of engineering tasks to be performed. It was gonna take longer than than everyone realized. I understand there is a letter in the packet saying that there's certain agreement about certain work to be done, but for me it was, and the reason I voted no in executive session was because of the just the administrative process of making sure that everything's complete before we move forward. So it's not really, it wasn't for me, it wasn't a position on the NOI itself. It was really stating that we should be methodical and have, conclude our obligations, both parties. And I know there were, fault a lot on the town, and we didn't do it on a timely basis, but that doesn't preclude the obligation to make sure that's all done. So.
I meant, before I said anything, before I take action, I wanted to repeat that I filed a disclosure, and it's with the town clerk, about the engagement that I'd had with Coastal Conservancy prior to 2016. So it's there, and it can assure everyone it doesn't impact my decision, any of my decisions, or reasoning behind my decisions, in the context of the open meeting law.
Always good to disclose. Matt or Dawn, any thoughts?
Well, I just wanted to clarify, the vote that was taken in executive session was just whether to bring this into open session tonight or not. And it was split. And the contractual piece that wasn't done quite to our satisfaction was having the fully engineered shovel-ready plans for the alternative access, which was part of the agreement. And what has been signed is an agreement to have that all done and delivered by September 30th, with the understanding that if an NOI was granted, or the assent to an NOI was granted, that if that obligation was not met, the NOI would be withdrawn, is what the current proposal is.
I think my concern is that is putting us right back in the position where we are unclear and inconsistent with how we deal with contractual obligations. And people expect that that we will be lenient, or that we don't really mean what we say in these contracts by saying, if you get it done by then, we'll give you this first. I think, which is why I voted against bringing this here, although I believe in the transparency of the conversation. To me, this is where it is a hard line of, these are the obligations that we agreed to 2015, and we should meet those. And I think both sides have an element of accountability for not having the diligence to have been discussing this a year ago, but pushing it forward without meeting those obligations, to me, doesn't fix the problem. And I think it perpetuates inconsistency and being unclear, and the idea that we'll be kind because there's been a timing issue.
Mr. Chairman, can I speak on this? I think I have to take some exception with the characterization of a failure to meet an obligation, and I don't think that there was any failure by SBPF or frankly by the town. I think that looking back 3 years by people who weren't involved to say, hey, do we have everything that we want? And saying, no, we don't, and we legally have the right to ask for more, is a little different than saying, hey, the ball got dropped and people didn't satisfy their obligations. And so I just really want to make clear for the public record that actually a tremendous amount of time and effort and money and goodwill was put into developing the alternative access agreement, and a plan, an agreement, and legal agreements were signed and prepared, actually far in excess of the obligation that is required if you go back and read the agreement. And those agreements that were signed and prepared and delivered to the town actually will save the town a ton of time and money in other ways. However, the engineering to follow through on the development of that road, which will take a couple of months, was not done. And if that is something that the town wants, SBPF has already signed the contract to have that delivered, and it'll take a couple of months and it'll be delivered. So the suggestion that people who didn't do what they said they were going to do were asking for more, or any characterization remotely close to that, or even frankly that the town staff dropped the ball, I think is an unfair characterization. And if that's not what you're saying, then fine. But I really don't want it out there for the public who is not involved in all the details on this to think that either the town or the neighbors didn't do the right thing. At the time when all that work was put in, everybody felt like, wow, what an accomplishment, we got a lot done. Nobody thought, we did half, let's break. The retroactive look back of, hey, did we get everything we really want now, turned up, hey, what we really need is some engineering, and that's being delivered. But there was never a request for it or a desire for it that was ignored or abandoned. So I would say that SBPF delivered more than it was supposed to, and the town did a diligent job, and that now, looking back, the town has figured out, hey, we could actually use a little more, and I see a hook to get SBPF to pay for it, so let's get it. And that, like I said, will be delivered in a couple months.
I appreciate that, because if it came across, I think the wording is important, and it's not so much to me that it's a failure to an obligation. To me, it seems like there was a lack of clarity. And again, having this discussion 6 months ago, or at this stage 10 months ago, would have been ideal. I don't think it was intentional, but I do think there was a lack of clarity. And for myself, coming in when I came into this, reading through the agreement, to me, it was fairly clear that there was this alternative access plan. I don't feel that it was, oh, by the way, and we need this. To me, it read fairly clearly that this was an obligation. And I do appreciate the work and the effort that has gone into all the other requirements, the monitoring, and you're meeting the obligations that were clear that you had to meet. So I don't want it to be painted as a failure to meet the obligations or anything intentional, but I do think there was a lack of clarity. And
Yeah.
it could have been rectified if we had brought this up
And-
before the deadline of January 2018.
Yeah, and I would agree with you that taking some time off and taking a fresh look and thinking, what do we want now and do we have it, was a good exercise because it revealed the fact that there was a survey plan and not an engineered road plan, and that's one more step that's needed. And like you said, it's being contracted for and it'll be delivered soon. Thank you.
Matt, any
How are
thoughts?
you going to do this? Are you going to ask the public for their comments, or what's the?
If there's no public comment, then we can keep discussing and we can take a motion or not if we feel ready. Or we can, we can table it, there's lots of different decisions. I like how it's going so far. We're all talking, we're all giving our opinion on.
Well, yeah, I think I was involved in the negotiations, and I think, and I think that it's looking at it now. The negotiations, in my mind, it was we were facing a larger, potentially rock revetment, with, and the island did not want that. This was proposed, a smaller test was proposed, which was agreed upon, and which has had, 3-4 years?
Yeah, some part of it's been there 5 years.
All right, so which was agreed upon. If in that period or in some future period, it fails, and there's a bunch of criteria for that, if in some current period or future period it fails, we have the CONCOM can say it's failed and we can remove it. And, so in part of that negotiation was the understanding that at this period, they would be, SBPF we would have 3 years of data and they would be allowed to apply for a further extension. At that point, and that was a negotiation, and quite honestly, they were not happy with that date, and some people didn't want it for 10 years, and that was what we ended up on. But if in fact, it goes to CONCOM and it's the worst thing ever, and it's harming other beaches, and it's the end of the world, then I would hope that we would say no to it, and that would come back to us and we wouldn't license it. But I think that they should have the opportunity to go and fulfill, at least I would like, as one member who gave my word 4 years ago, I would like to keep my word now to let them go and have that review. And, if I find that review is wrong, that, if there's something that really bad that we haven't thought about, if there's changes we have to make, then, we can deal with some of that in the licensing. I think there's things that we have learned, sort of like this last issue. I think there's some other things that, that we would want to potentially discuss in a license, but I think that there's, to not be in this situation again, or if we do find it fails in 15 years or 10 years, that we have a way to safely retreat, and that we aren't fighting over who's going to do the roads, et cetera. I think those are issues that are going to be very difficult in another license agreement that are going to have to be hammered out. But I think the first step is, having it evaluated at the CONCOM level. And I would feel uncomfortable. I don't think there's anything that's happened that would cause me to say they shouldn't go there at all. And that's just as one person who was involved on the committee that made the very difficult decision to be where we are. So.
And that is the part of it. Matt was here and others were here, and we have come into this and are learning and need to somewhat look to what's been done before us and what's been already been agreed upon. But we have had extensive conversations as well, hence our numerous executive sessions about what may or may not be in a license, which would, if we were to vote to grant the NOI, that does in no way obligate us to grant a license or to not discuss significant provisions in a license.
So Matt, you're okay, you would be okay with going forward with an assent with the recommendations of making sure that this access gets done by a certain time? Being contingent on that?
Yeah, man, and I think that's, you know, that is that issue, I think, has, how do I say it? Yeah, well, I'm not finding my words on that. There's other issues that I think are bigger than that. That access is very important. It was part of what we were worried about back then was, what, you know, how are we going to access that part of that road? You know, if it broke through where it looked like it was going to, how would we access? How would people be able to walk up to the lighthouse anymore? And so that's what we were sort of, and that was very difficult. You know, to be completely honest, there were a couple homeowners who, you know, we had who we didn't have to, you know, you had to convince them that, you know, to have a road pass right between their properties, right next to their houses. And they agree, you know, and they thank you very much. And they agreed to do that, you know, as part of this negotiation. It was not easy. And, you know, and that is all laid out. So if that has to happen, it can happen. You know, we had the golf club come and have engineers and, you know, did calculus and show us how, you know, it couldn't go within so many feet of a swing and everything else, which, you know, they basically what they really had to say was we need to move the road over a little bit, you know, with the calculus and some of the other stuff was a little unnecessary. But I think that's, you know, so we had, this took up a lot of time a few years ago. So, and I think some of that should hold sway now. Now, but what I don't want to see happen is I don't want to see, if it goes to CONCOM and they are absolutely opposed to it, I don't think that we as a board should be fighting with CONCOM. You know, I think that's our, you know, I just think that would be a mistake. We shouldn't be in opposition to them, and I don't think it's in our documents that we didn't have, that we wrote, said that CONCOM had the final say on this, on the performance of this and the oversight of this. That wasn't our board's, you know, jurisdiction, even in those documents.
We're going to hear from others. No one's standing up, so I guess that means.
Yeah, no, Rick. Rick and then Cormac.
Yeah, my name's Rick Atherton, and I participated with Matt in virtually all the discussions related to this issue. And I have a couple things tonight, but I want to just say one thing up front. I think we all need to understand what is likely to happen if you do assent and sign on as a property owner. It's clear to me everything that happened before could happen again. The CONCOM denied the project twice, and it didn't make any difference at all because they just appealed to the state, and that will happen again. Once you start this process and the license has not been negotiated, it's being put off because council likes to tell you you can always do it later. No problem. You know, and if you don't put a condition in this, let's be really frank, that they could apply, but they cannot appeal a negative decision by our CONCOM. If you don't put that in, then they are going to get approval. The state has clearly made sure that's what's going to happen. So you're really voting to put in a mile, virtually a mile of geotubes on a public beach with all the consequences. Because once you start, you're not going to be able to stop it.
So, Mr. Chairman, Stephen Cohen, I represent SBPF. Let me give a little bit of background here, and then I'd like to address Mr. Atherton's point, which is that, you know, in 2013, we came back from one of the worst storm seasons ever, where properties that had existing erosion protection that had been permitted by the CONCOM were losing 20, 30, 40 feet of bluff in front of them. And this board voted to jointly go with the SBPF to apply to the CONCOM for a 4,000-foot rock revetment. And that went through months and months and months of permitting, and then we quickly realized, wait, we're going to lose the road while we go through this permitting, and so we had a concurrent application for 900 feet of geotubes just to deal with the portion of the road that was the most endangered. We then came back and said, okay, well, let's try applying for just 4,000 feet of geotubes, because as we've gone through this process, we figured out that maybe they're better in some ways because they're removable. And that 4,000 foot application was put forward, but then the 900 foot application was approved by an emergency permit and brought back to the town. The appeals that were filed to the state were approved by the state, but what's important to understand is that when the CONCOM issues a permit, it's actually issuing both a state and a local permit. And so only the state can't shove it down your throat. They can only issue a superseding order of conditions on the state portion of the permit. And so the state portion was appealed, a bunch of legal questions were answered in that state permit, and it was brought back to the Conservation Commission. And it is the Nantucket Conservation Commission, not the state, that issued the permit that approves what's existing there today. And anybody who tells you otherwise should go back and look at the permit that's recorded at the Registry of Deeds, issued by the Nantucket Conservation Commission after the appeal was sent back down here. It is the local permit that currently exists. No one forced anything. The state only answered legal questions that the CONCOM, we think, got wrong. But that's fine. The CONCOM, it was a very difficult issue. There were a lot of novel issues. There were a lot of issues they weren't used to. And they wanted, people wanted to see what does the state have to say on some of these things. But the permit that's issued is a local permit. It was a compromise between the Board of Selectmen, the Conservation Commission, and SBPF that resulted in that permit being only for 900 feet instead of the 4,000 feet, but it wasn't for the emergency permit construction. The emergency permit construction was only for 3 tiers of geotubes, and the CONCOM approved going to the full 4-tier height in its locally issued permit, but the compromise was, okay, you can go to the full 4-tier design, but don't go the full length. Let's wait and test that. It's been, the 3 tiers was in place for 2 storm seasons, and we went to another 3 seasons for the full 4 tiers with all this mitigation in place and all of this data collection in place, with the idea and with the agreement that we would test the 952 feet that's there and then come back in 3 years with those lessons learned to go back and apply for what we're applying now. Yeah. Sure. Okay. So the only question in front of you is, should we stick to the agreement that was agreed to of letting the CONCOM now go back and review the full application in light of all of the information that we have and make any adjustments that should be made based on information, and those could be positive or negative information that's been learned. And this board is not legally required to do anything, and the CONCOM is not legally required to do anything except stuff they're already legally required to do. You're not voting tonight to let the horses out and you can never get them back. You don't have to sign a license later. You can put whatever conditions you want in its place. And if the CONCOM has to issue a permit, it's because the law says so, not because the state says so, not because I say so, not because you say so. Nobody can force the CONCOM to do anything. What they really should do is be left alone without any rules in place except those that already exist to make a fair and unprejudiced decision, not one with a Damocles axe hanging above, oh, well, you can't do this, you can't do that, whatever. Let them operate in their professional and legal capacity. And that's what I'd like you to do tonight. I'd like to request that you vote to authorize the notice of intent to go forward so that the CONCOM can do their job. And then if they issue a permit, you would then have the ability to review that permit and say, okay, we like it or we don't like it, and we're willing to give a license for it, or we want to add these conditions to it. And that, as the owner of the land, is something you should do once you know what you're being asked to review, which at the moment you don't because there's no permit for it. So that's my request, to authorize the CONCOM to do its job.
Got it.
With the idea that we all come back.
Thank you.
Thank you.
Cormac?
Oh, I'm sorry, one thing. I do want to note, there's a number of people from Sconset in the room and a number of people who left because they've been sitting here for several hours and unfortunately didn't make it this late in the meeting.
Okay, we'll go to Cormac next. You've been waiting.
Thank you, Mr. Chairman. Cormac Collier, Executive Director for the Nantucket Land Council. As you know, we do most of our work before the Conservation Commission, and we'll hold all of our review and comments before then, if and when it does get there. But I do want to reiterate something that I did say a few months ago, and it actually is even more pertinent with the comments from Mr. Fee, in that if the CONCOM does deny it both under the state and local law, Mr. Fee was just basically said that then we would want to support our Conservation Commission and not issue a license. Well, unfortunately, what will happen is, as they have said, that they will most likely appeal that decision under the state and the local, bring it to Nantucket Superior Court. The town's going to be spending unnecessary money defending the Conservation Commission's denial if you don't issue out some sort of condition that they give up their appellate rights. It just doesn't make a lot of sense for me if you go down, if you want to support your Conservation Commission, as I do, if they issue something very thoroughly, which what the council does, why would you then open up the door to an appeal that the town would then have to spend public money to defend? It just doesn't make a lot of sense to me. If you want to think through that as it relates to a public benefit, public resources, I understand that, but there's a little bit more conversation should happen on that end. Maybe it already has an executive session. I imagine you guys probably went over it over 5 meetings, but again, I just wanted to make that point. And as you know, we hold all of our stuff for the Conservation Commission scientific review, which shouldn't be before you. Thank you.
Thank you.
I want to address Amos Hostetter at 53 Baxter Road. I'd like to address both some comments that Mr. Atherton made and some comments that Cormac made. I was one of 4 people who are here tonight who was involved in that 2013 negotiation. And it was Rick, and it was Matt, and it was Josh and myself. And we had been in court for 2 years with an appeal to the CONCOM, a decision by the CONCOM, and a threatened appeal of the decision by the CONCOM. And we all decided this was not money being well spent. There ought to be a way to find common ground here. We sat for 2 different meetings, and at the end of those meetings, we decided we would rather defer pushing this thing for another 3 years, which would provide a total 5 years of testing of this barrier, on the understanding that if at the end of that period the CONCOM decided this system had worked, that we would be allowed to go forward. So we traded 3 more years of damage to a bluff that was very, very vulnerable without protection, for the assurance that after the end of that period, we would be welcome to come back to CONCOM, which was January of this past year. That was a deal I made, that was a deal Matt made, that was a deal Josh made, and Rick, that was a deal you made. There were no objections, there were no minority dissents or anything else to that report. So I would say to you, the simple equities here are pretty darn clear, which is a deal was made with that group. I understand that it's taken now 7 months to get the new members of this board up to speed on this, but those are the fundamentals of the deal. Now, as to Cormac's comment that the board should do this on a condition that we forego any right to appeal if the CONCOM denies this, is out of some science fiction movie. I mean, no one is going to do that. Our judicial system is what our judicial system is. If the CONCOM feels they were mistreated, they have a right to appeal. If we feel we were mistreated, we have a right to appeal. And no one going into a situation like this is well advised to, in advance, waive a right to appeal. So I would say for a land council that has nominally declared that they are a non-combatant in this process, to come forward at this point in the process and say, let's add a little provision that Sconset Bluff people will not appeal if they lose at CONCOM, is absolutely an unacceptable provision. Thank you.
Thank you. Judith? Somebody else?
Good evening. My name's Judith Wagner. I live at 50 Quinnet Road. I'm also a member of the Planning Board, but I'm not here in any way on behalf of the Planning Board or in that capacity. I'm here as our council told us earlier today that if you're going to be in front of y'all, we have to tell you who we're speaking for. I'm speaking just for myself. You've heard me speak previously. You know my background as a retired law professor with expertise in this field, although not everybody believes I have expertise, apparently. I've done more work on this. The historic research I brought to you previously, tried to pursue that more, but I have three main points because there's limited time. First thing, I think you have to be careful about using the framework of contract when you're engaged in regulatory activity. There's times in which if you're engaged in partnerships between public and private parties, that can make sense in my mind, but as far as the public at large, or I myself am concerned, I look at this as really a question of protecting the environment here, natural resources, and I think you really have to be aware of that. I don't think that past boards can constrain future boards in perpetuity in some way about doing their obligations about their police power oversight. So I would just urge you to think closely about all that. If indeed you decide you're going to enter into what amounts to a public-private partnership, I think the citizens deserve to have better and fuller information about who the private partner is. I know this is an organization that has been created. I think the last time I looked it up, it has some sort of federal charitable tax status. I'd like to know, based on my own work historically on things like homeowners associations that last for a while and then go away, or I'd like to know too with tax law changes who we're dealing with down the road, if this is going to be some kind of a in perpetuity mile-long geotube complex. I think the citizens need to know what the backup is about that, because as we know with changes in the economy, ownership and things of that sort, if you are going to be dealing with the partner, you really owe it to everybody to be very clear about that. Last thing I want to say is we have Article 97 of the state constitution, and I think that you need to take that into account. I'm not sure whether that was taken adequately into account when you dealt with this previously, but I've continued my researches to Mr. Fee. I've now found the old documents out of Parliament and otherwise about how New York gave up its claim on Nantucket lands and Massachusetts took over and how that all worked. But it's a long haul to be going from 1692 up to the present, so forgive me if I've not fully gotten there. But what I do have to offer you tonight, and I'll send it on to Erica to be distributed, is a reference to a deed recorded in Book 102, page 119 of our Register of Deeds dated May 1st, 1925, and that has to do with the bluff, not the part that is on the water, but the path. Very explicit about that, and if anybody doubts that there really was an intent clearly to create a trust here, I think you really should be reviewing this document closely, because it said, referencing the bluff, that the proprietors, I'm going to just read it to you here. Referencing lots A and B on a plan entitled Land at Sconset, Nantucket, the path surveyed for the town of Nantucket, September 22nd, 1924, giving the name of the engineer who was involved in that, said that this was going to pass said land to the inhabitants of the town of Nantucket and their successors on the same trust as is contained in the flag deed. That's the same flag deed in a separate provision of which the beach easement was created on behalf of the public for the purpose of a way or footpath along the lands and for no other purpose or purposes whatsoever. And said land or any interest in same is not to be deeded away by said town to any person or persons whatsoever. This release is given upon the following conditions: that said inhabitants of the town of Nantucket shall cause said land to be registered in the land court, or so much of the land as the land court finds entitled to registration within a reasonable time, but in any event to complete the registration within 5 years from the date, or else said land shall revert to said proprietors. I don't know what would be a clear indication of a serious intent to create public trust. Now, that specific reference is to the bluff path, not to the easement on the ground at the beach. However, when the deed and the plat related to it were originally created by Mr. Flagg, the proprietors, that right did not extend over the bluff. It was very clear on the map there that he was aware in creating that deed, and the proprietors were not to be giving rights that would extend up to the edge of the bluff, but to try to set up rights on the area of the land above, not affecting what was going to be going on down next to the ocean. And the provisions of that original protection, that public easement in the beach, are something you're bound to protect. You really owe that to the public. We owe it to the future. I understand people living there don't want to lose their land, but they're in a situation where this is a public resource that you all are holding in trust on behalf of the inhabitants. In my personal opinion, I think a group of citizens, if there's any doubt about this, should go about bringing an action in court to try to get an interpretation of the state constitution to provide that. Ideally, I would urge you all to do that before you go ahead and let things move ahead further, because if you don't, you're looking at potential claims that you should be reimbursing property owners later by virtue of some kind of delay brought about by people in litigation with you. So I just ask you sincerely, and only personally, not in any other capacity, not to sell out that birthright. Thank you.
Thank you, Judith. Josh?
Josh Posner, 77 Baxter. I want to just make two points without repeating too much of what's already come before. And I don't want to get into this whole discussion that Ms. Wagner has brought up. I heard that, we heard that 3 or 4 months ago, and I think it was referred to town council, and the lawyers kicked that around for a while already. Tonight, I think we've got something that is fairly simple to decide. Are you ready to send this to the Conservation Commission? As Amos Hostetter described, we had a whole process where we tried in 2015, 3 years ago, to come up with a way forward on a project that was tied up in court with all kinds of legal fees getting spent. And we did come together around a good faith agreement on how to move. We agreed to wait until January of 2018 to request the expansion of the project, which we always needed and always have talked about. That gave the town a total of 5 storm seasons of data to decide whether the project was working or not. When we came in January to ask for the notice of intent to be signed in accordance with that good faith agreement, new members of the select board said, we've got a lot of questions, there's a lot that we don't know about all of this. And so we've now spent the last 7 months in many meetings answering every question that you've had to the best of our ability. Now, it appears that in the process of that, in the last month, the town has requested some additional engineering work relating to the alternative access. I feel very strongly that we asked at various points over the last 3 years whether there was anything else we were supposed to be doing in accordance to that, with that alternative access. And I'm quite sure everybody agreed that we'd done what we said we were going to do, which was more than we promised. When we said we were going to try to get an alternative access route, we couldn't promise that we would be able to deliver. It was a tremendous effort to bring this community together and make voluntary agreements that would result in the town not having to go through a contentious, confrontational, difficult, expensive, eminent domain process to create an alternative access in a hostile environment. We delivered that. That was part of our MOU going back 5 years ago. Now, it's been decided this is the first I heard of the idea that there was some engineering that we needed, that you wanted us to do that hadn't been done, was a month ago. We're not arguing over whether we should have had to do it or not, whether we should have had to do it in accordance to that agreement. We said, okay, fine, we'll do it. And we have contracted for doing it. There's a date certain when it will be delivered. The decision tonight is really pretty simple. Have you, after 6 or 7 months of further investigation into this project, is it working? Is it hurting anybody else? Are we in compliance with our permits? Are you ready to send this to the Conservation Commission as it was described in the good faith agreement that we entered into 3 years ago? That's the question before this group. And we have still probably 25 people, 20 people from Sconset, raise your hands, who are here, who have been doing everything that we've been asked to do, spending hundreds and hundreds, millions of dollars protecting this road, protecting access to the Sankaty Lighthouse, in the face of nonstop opposition from a passionate, principled group that doesn't want this to happen. They've done everything that they can do to oppose it, and they have every right to do that. But at a certain point, it's time to stop going around and around and around and to start moving forward. That's what's had to happen at various points over the last 5 years, and that's what needs to happen again tonight. Thank you.
Josh?
So, Mr. Chairman, and you may rule this out of order, but I'd like to make a motion, and I would like to make a motion that we approve the assent to seek notice of intent from the Conservation Commission for expansion of the erosion control project with use of town property. I've spent the last 7 months, and you know, I won't debate some of the comments I've heard, but you know, I've come to the conclusion that I'm ready to support sending this forward. So I would make that motion for discussion.
Second for discussion?
Second for discussion. We've got public.
Yeah, there's somebody had their hand up right before you started that. Would you like, would it be okay if we, during your motion, would it be okay if we?
No, it's been seconded for discussion, so.
Okay.
But this public comment, I don't mind if there's public comment after.
No, of course not. No, I mean.
Okay, please.
My name is Barbara Bund. I'm with the Conservation Commission. And I want to remind you of something that happened at your earlier meetings this spring. Jeff Carlson from the Conservation Commission stood up there and told you that there were issues about sand and that the CONCOM cannot deal with those issues about sand. And I presented some numbers to you based on assumptions that I tried to make as favorable to the Sconset property owners as I could, because I was trying to get a common argument. And they showed how much sand was going to be needed for an extension, let alone for the current installation, and used estimates from their consultants about how much sand there is in the 2 pits on the island, and showed that, you have these numbers, I haven't brought them with me again tonight, but I put them in the record in the spring, and showed that within a few years, if sand was needed for nothing else, this project would exhaust the supplies in those 2 pits. No construction, no town use, and so on. At one of the meetings this spring, the head of SBPF said that they were exploring other options for getting sand. He mentioned a few, and I shouldn't be saying what he exactly mentioned. I think there was talk of off-island and dredging, but whatever. It seems to me that before you go ahead with something that is going to use up our sand, and the CONCOM cannot consider that, that's what Jeff told you, I think you really need to consider, where's the sand going to come from? if they're looking at options, they shouldn't be ready to go ahead. They should have those options clear, explained to all of us. And you also ought to look at what that's going to do to prices, what it's going to do to town uses of sand, to construction uses of sand. And the other thing that we mentioned in the spring is with, I think they're now on the order of 1,000 truckloads a year that go out there, and there will be many more. What happens to the cost for the roads? So the idea that people have been spreading that this isn't going to cost the town anything, it's going to cost other people in business on this island because of the sand. It's going to cost the town to maintain those roads. And the CONCOM can't look at that. So I would really like to see you look at those issues in your job as being responsible for all of us before you give them a go-ahead, a green light, which at least in some people's view is going to lead to the state and lead to an approval. Thank you.
Thank you. Don,
I think
wanted to
we've done
respond?
that. We've done that.
I was
so.
just going to say that we
Yeah.
have
Yeah.
started that discussion, gone through a lot of that discussion, and it would certainly be a very serious consideration into any licensing.
Yeah. We've got a lot of data on number of loads, so it's, I've seen the truckload numbers and the wheel, the size of the axles and those kinds of things. So that's pretty well defined, and we're assessing that. Rita?
I'd like to make a couple comments. One, I feel there's sort of two layers to this. One is are we ready to put it to vote on the NOI without those obligations, regardless of how they were missed to date? Are we ready to push it forward without those obligations being fulfilled? And again, my answer to that is absolutely not, because I think it is perpetuating what is becoming a consistent approach to contractual obligations where we haven't gone through them in enough time to make sure that everyone understands exactly what needs to be done and when. So that's my feeling on what we're discussing today. September 30th or October 1st, that would be different because the contractual obligations have been fulfilled. And I think it's important to set the foundation or start again and cultivate this relationship in the way it should be cultivated, where it's clear. So I don't think that has been fulfilled at all. Secondly, there's a couple things that just make me uneasy, and I'll bring them up now. I think, we have had many discussions, and I think board members know exactly where I stand on when I would be ready to consider an NOI. And the honest truth is that I feel this is a policy decision. I think sending it to CONCOM is pretending that this is a site-specific ecological problem. This is an island issue, and this project needs to be looked at in the context of how we're going to approach coastal erosion, sea level rise across the community. And we need to be able to look at the various projects, look at our vulnerabilities, estimate the costs and the inputs and the logistics, and they need to be vetted and prioritized one against the other. They're ahead of the curve. They have the money to be able to push this to the forefront, but that's not good policy. And I think it is the onus of the board to understand when it is a policy issue and step back and say, we need to look at this in the context of the bigger picture. So for me, and that's not what anyone wants to hear, but that's when I would be ready for the NOI. So there isn't a time frame on that now. We have a coastal resiliency plan underway. But a couple things that have made me uneasy. One is this. I think it's very unfortunate that this good faith agreement was made. I think the outcome was what we wanted, but this is why good faith agreements that are not legally binding are not made. Frankly, I think they're inappropriate because one side is vulnerable to their expectations not being met. And unfortunately, it's SBPF. It was not legally binding, and I don't feel compelled legally or otherwise to be beholden to that decision. And again, I think it's unfortunate, but it's an inappropriate way to to come to an agreement and then expect the board to stick to that. I'm very uneasy by the sense of sort of a fait accompli, that they get the NOI, the assent to the NOI, it goes to CONCOM. If CONCOM doesn't approve it, it'll get appealed. And again, it's setting up policy that is being driven by political pull, connections, and money. And I just don't think that, whether that's the way of the world, I'm not ready to concede that that is how we're going to let our policy decisions be driven. I also am uneasy with this idea that if we don't like them, we can just take them out. I think it's very flippant And I think it's flawed thinking, because really and truly, if we don't like them, we're not going to like them. Maybe they haven't worked. Maybe Baxter Road isn't being protected anymore. But if we don't like them because they're having a negative environmental impact, you can't pay to fix that. You cannot pay to fix that. That's 30 years plus to repair. So the idea that, flippantly, that we can just take them out and everything's good is wrong. It's flawed, and I don't think that we should be treating our natural resources so flippantly. And I think there may be a time where we decide, the town, the community decides that we are going to hard armor. And when we make that decision to hard armor, everyone needs to understand the damages that are going to happen. And again, I think this is just out of order in that it needs to be looked at in the context and really understand what those consequences are. And I think, unfortunately, again, that this 5-year time frame, I really appreciate all the emails that we've gotten from Sconset, and I think they made some good points. But I think that while it has protected the road, which is a positive, the idea that we understand the impacts in 5 years, again, is flawed. The systems do not work in 5-year increments. We won't see the damage or negative or understand the impact for more than 5 years. So that's, and the last one, and this has come up, and it sort of was reinforced by the open meeting law conversation. If you feel uneasy about something, there's a reason. The fact that this is not going to town meeting in some way, shape, or form, to me, I feel very uneasy about that. And I don't mean it to be a, do we like SBPF's project or not? I don't think that's what it is. To me, this is a broad, much broader conversation with the community about what we are going to do about coastal erosion and the approach we're going to take when private property is involved and there's a public-private partnership. And that could apply to SBPF, it could apply to Matticat, it could apply to any of the areas that are going to be impacted in the near future. So I feel uneasy that this is not going to town meeting in some way, shape, or form. So those are my comments, and some old, some new.
Are we ready for a vote?
Just another,
Sorry, actually, well, if there's someone else as well, while we're waiting for someone to
and I
come.
wanted to ask to John, what is there was a comment tonight about Article 97. Does that apply? Have we discussed that? I don't recall that we have. And does that apply here? And you've probably read what Rick sent us earlier today.
Well, I've been a little bit busy today,
Oh, all right.
to be honest with you.
I asked Libby and said town council was going to
But,
review it.
All right.
So, yes, of course, we're familiar with Article 97, and we have looked at it with respect to this project. And we will be, I think Jim has requested it, we will be providing the board with our view. It's important to understand, however, that the issue of whether Article 97 is triggered doesn't occur when the board agrees to let the application go forward. It would only be relevant when and if the board entered into some legal agreement that granted them permission to use the property. Now, it's our view.
So that would be the license, if we licensed it.
Correct.
And then we licensed something we shouldn't have licensed, that's when it would come into effect.
Well, so if you were contemplating granting an easement, which would require town meeting approval, and it would trigger Article 97, there's no question about that. We're talking here, and what the discussion has been, is a license agreement. And I believe the Executive Office of Environmental Affairs has indicated, and their job is to interpret and enforce Article 97, that a license agreement does not trigger Article 97. So that's sort of the Cliff Notes version. But it would definitely be an issue if the board was contemplating, or if SBPF requested a permanent easement, because that is a disposition of an interest in land, and that would require the legislative vote. But that's not what we've been discussing.
Thank you.
Rick?
Again, my name's Rick Atherton. Just to pick up on the Article 97 issue, I did prepare what I'll call Rick's understanding of the public information available about Article 97. And I came to look at before this spring in the land bank situation, I didn't know Article 97 of the state constitution even existed. It was not a matter of discussion that I recall before the board when the use of the town beach in Sconset was being discussed. I don't think I understand what town council just said. I think there are issues about Article 97, which is intended to conserve conservation and recreation land within the Commonwealth, and any change in use or sale of that type of land needs the vote by the roll call of 2/3 of the state, both houses of the state legislature. And I went through and tried to find some legal cases related to this. And one of the important distinctions the Massachusetts Supreme Court made was that the ultimate test of whether 97 should apply is the use of the land. And it seems to me it's clear in this case that this is public land. It's meant to be a beach and conservation land all along. And I think when we're using 4 acres of conservation land here, it should require a vote of the owners of the property. That's town meeting. It's not 6 of you or 5 of you trying to, I shouldn't say it quite so pejoratively, but when you're using a license, it's clear to me the use of a license is intended to get around going to the voters of the town who own the property. This is meant to be a permanent installation. It's not meant to be short-term. It's meant to be there forever. And while it's not technically the sale of the property, it in effect, substantively, is a permanent use of the property by a private party. And I think any such kind of transaction ought to be voted upon by the citizens of Nantucket who own the property. And that's really the conclusion I came to about after I went through all that I did to understand about Article 97. And I just thought Beaton's letter to the land bank was somewhat instructive. He won't even approve without some more action to build a dormitory on a parking lot because of Article 97. And here we're talking about not a parking lot, but a public beach owned by the citizens of Nantucket. And I think you'd be well advised to take the matter to town meeting in some fashion. If you don't choose to do that voluntarily, I think we all know it's not very hard to get it there by the petition route, if it's necessary. Hopefully that's not necessary, because I think it's in your own best interest as sitting selectmen representing the citizens to make that decision. Thank you.
Mr. Chair, I look forward hopefully to a positive vote in which the Conservation Commission could decide whether or not to issue such a permit and under what condition those permits would exist. And I would like to point out that the benefit of this permit, if it's granted, and the sand that would be used for it, is that it actually saves the public beach from the erosion that would otherwise cause the public beach to go underwater. So I look forward to my grandchildren being able to go on this beach because it is preserved essentially by this permit. And I'd ask you to vote to allow the CONCOM to consider making that happen. Thank you.
Mr. Chairman.
Jason, just
Oh, sorry.
one more comment on that note is that I think that looking at what we have learned, using this as an experiment to see what do the geotubes do, how does it work on Nantucket. Again, I think the environmental impacts are unknown. Did it save the road or support the road? Yes. But I think that what I have really learned, and I think it's very sobering, is that geotubes with this constant sand mitigation is incredibly expensive. And I don't think we don't have an answer as to, is it even feasible to consider to continue to do this long term? And so, that's the one thing I have learned, which again brings me back to not being ready to hand this over to CONCOM at all, because we haven't answered, haven't even come close to that.
Well, why I think it's a better option is because if we had put rocks, if rocks would have been approved there, rocks would require similar sand mitigation. That's what they're doing now at the state level. If the money ran out and they didn't do it any longer, we'd be stuck with a bunch of rocks that were being undermined and buried in the sand, and we'd not know what to do with it. If in fact something happens and it falls apart and they don't take care of it anymore, you can go with a crane and take this out. And and they haven't been taken out of very many places, but they have been taken out in at least one that we've read about. And so that's where I think there's a difference between the option that we were facing 4 years ago and the option we have now. And I think that this option is something that we could remove if we had to. So I think that's, in my mind, that was a better choice. And I understand your concerns, and I understand the concerns on the sand. I understand the wear and tear on the roads. I understand a lot of the costs that the town is facing and the homeowners are facing. There's a lot. This is very complicated, and so the algebra that I've come up with, I'm uneasy with, but I'm comfortable going forward, at least to C at this point.
I'm concerned about all of the things that have been raised. I don't feel adequately prepared or that things are in place for the alternative. I feel like that we need the alternative access ready. I feel like, that this is not permanently sustainable as a project, but I mean, I may be wrong in that, but that we need to know what we're doing. We need to plan for retreat, and we need to have that stuff in place if that's the eventual outcome. And we don't have that yet.
And I think for me, not that we just need to debate all of our, but I was very, I strongly believe that we need the coastal resiliency plan, but I think I was also swayed by arguments that Don and others, which is, we have to have that, the engineered plans for the secondary roads, and we really currently don't have a good alternative. I was also swayed by the recommendation from town administration too. So it's been probably the hardest decision I've made since I've been here. But so I've learned along the way, and hope it works. I would say, and I hesitated to say this, but I would say the level of rancor on the part of some of the representatives, and as noted of the Sconset Bluff, is noted in numerous emails that are public. I hope that stops, because it adds a level of conflict that we don't need. So, and I'd be happy to share with any of you the emails that I'm referring to. Thank you.
Ready for, I'm sorry.
No, this is not a marijuana recreational thing.
You missed that discussion.
Right, boom, sorry. Karen Warner, I'm a resident. I'm also a co-owner of that beach. I'm a co-owner of that beach. And you're elected officials who are going to give away that beach. And I understand it's for people who have their homes up there, but this was set up years ago, thousands of years ago, whatever, that there were 2 lots that people could move there. I understand that we're losing potentially a bluff, but we're going to lose a beach when you hard armor there, and that's my beach. That's the beach of all the people who live on this island. And I am sorry that Mother Nature she can be a wench. Have you ever walked on it? I have. And it's remarkable. And you know what? It's not going to be there. We call it, you call it Sconset Bluff Preservation. It's actually Sconset, you say it's the beach preservation, but what you're doing there is destroying the beach, not the bluff. It's both is happening here.
Let's talk to.
Oh, I'm sorry.
It's okay.
I'm sorry, but when you hard armor there, you're going after the beach. to potentially protect a bluff. You're ruining the beach. So this is actually Sconset Bluff preservation. It's not Sconset Beach. That's my beach. And I beg you not to give it away, not to sell it off. That's my beach. Just say no, really. Or turn it over to the people of Nantucket and let them vote on it. Because we elected you, all of us elected you. Don't give our beach away, please.
Thank you. There's no one else from the public? Deanne?
I'm Deanne Atherton, and my birthday is August 1st, just as Mariah Mitchell's is. I'm not going to be 200. I'm feeling like I am. I had some talking points, Erica. I don't know if you can bring them up or not. We're not going to do that. All right. Well, I have them here. I think, so let me make a couple points. One is, our focus is the same as it's been since we were founded in 2012, and that's the beach. And you've heard people speak about the beach. That is a public beach. It's a legacy from the proprietors. It was conveyed to the town, and you have a trust. That trust is yours. As you know, we had a non-binding ballot question this spring. We didn't campaign for it. We achieved almost 80% positive response. The voters want you to preserve Nantucket's beaches. We worked on that wording. You remember how we worked on that wording. It wasn't just the public beaches, it was all the beaches. And here we're talking about public beach. It seems like the intent of the voters is very clear. We sat through months and months of public hearing before the Conservation Commission. Our Conservation Commission has already determined that there are reasonable alternatives and that the geotubes have harmful impacts. They carefully constructed, finally, the state issued a superseding order, and the local Conservation Commission issued the order of conditions. And there were two special conditions that were of particular importance to us. And one was not too easy to quantify, but it was that a walkable beach may be maintained. The proponents never monitored the walkable beach. We brought that up before the CONCOM. We don't know how long a walkable beach was maintained or not maintained. I mean, we have anecdotal photographic evidence when the beach was not walkable, but we have no data. And the proponents have brought in reams of data, but they're silent on the amount of time that beach has been walkable. The second important special condition in both the DEP superseding order and the local order was that SBPF and the town report to the Conservation Commission every 6 months on the progress made towards securing alternative access and relocating the utilities infrastructure. Not once in 3 years has such a report ever been made. The order of conditions is still in effect. We think a case could be made that the proponents are not in compliance with the order of conditions right now. That's a very serious thing. Maybe what we have to do is we have to ask the Conservation Commission to open a public hearing to hear about that. We thank you for your transparency. We're glad you brought this forward for discussion. It's been silent for 3 months. We don't know what you've been dealing with. We don't know what information's been provided to you. This is our only chance to continue the dialogue, and the thought that you would, put this on the agenda and then make a motion and have a vote is quite frankly disconcerting and doesn't seem consistent to us with your concept of transparency. We don't know what you're being advised, and since we don't know what you're being advised, we don't know how we can provide information that would be helpful to you. What we do know is that the planning for the Coastal Resiliency Comprehensive Action Plan has started. And these very questions, a risk, excuse me?
I'm just.
Mr. Chairman, I have the floor, don't I?
Yes.
Thank you. It's just disconcerting to see someone standing at the other microphone. Thank you. What we're doing, and those who have attended the coastal resiliency workshops know, is this is exactly what the public is being asked to discuss. Risk, vulnerability, assessment, prioritizing. By your going ahead and allowing this to happen, and please, we've learned from past practice, once this permitting process starts, it will be very difficult or impossible to stop. There is a middle way, as we explained in April, and the timing couldn't be more perfect. This 900 feet of geotubes was permitted as a temporary structure for 6 years, a 3-year permit with the option to renew for 3 years. The current permit expires in September. The proponents can come in and have it renewed for another 3 years. That would give us time. It would give them time to become in compliance with the current order. And it would give the community a chance to go through the coastal resiliency planning process. It would give us a chance to have more data and to answer your question, Matt, which you always ask is, are the geotubes working? CONCOM hasn't responded to that.
I'm hoping they will when we send it, but.
You're opening a whole nother thing. They'll be evaluating, the proposal for 4,000 feet. They won't be saying, are the geotubes working or not? But they've been silent on that. And 3 more years of data would be very helpful. So it seems to us that that's a way forward that still leaves a lot of options. There's no rush. There is absolutely no rush. We've got a renewable permit for 6 years, and that we could move forward with that. We could tie up all of these loose ends. We could get the coastal resiliency plan, and we can come together as a community and move forward. Thank you.
Thank you, Dan.
Yeah, Mr. Chairman, I know you want to.
Hold on one second. I'm going to see, do we want to take a vote, or do we have any discussions, or that was some newer thoughts from Deanne. I don't want to keep going on and recycling conversations. Are you rebutting her back and forth? Are we ready for a vote, or we want to? I'm ready. The board?
I'd like to hear what Steve has to say.
Okay,
Just
go ahead.
very quickly, the assertions that SBPF is not in compliance with the Conservation Commission permit are blatantly untrue, have been raised on numerous occasions and have been rebutted on numerous occasions, and I will not go into the details now, but I want to go on record that the walkable beach criteria has been maintained and documented, and that the reports have been filed consistent with the requirements, and the suggestion that these are non-compliances is really an unfortunate misinformation campaign, and I hope that going forward we can all work to stop doing that. The rancor is really, really disappointing, and it's that kind of thing that causes it, I think. And also the suggestion that there's no rush, I would say that go look at all the empty lots on Baxter Road and ask those people that lost their homes if they think we're ahead of the curve, because that number is going to double and triple and quadruple as it goes down, and those people don't think that there's no rush. Thank you.
Any other comments? If there's no more comments, we'll take a vote.
I just want to say that, can I say one more?
Sure.
That maintaining town beaches is important to me, and taking things to town meeting is important to me. I don't think that if we do vote to grant this NOI, we're not seeing the importance of either of those things.
I would disagree with that, but I think that is exactly what we're doing.
But I would ask how, when loss of a walkable beach is a failure criteria?
And to clarify, I think when we don't take the appropriate time and consideration necessary to look at the beach as a system, we are minimizing the importance of the beach. It is a complete functioning system, and you have to look at it that way. And so when we don't do that, we're minimizing the importance of the beach and the public access to the beach. And again, I do think that there's an element of this that feels like it is trying to get around town meeting, and I think we are minimizing the importance of having the community understand the options as well as have the opportunity to voice their opinion.
Letting the CONCOM review does not necessarily take away some future vote of town meeting in terms of the land. I'm interested to see what CONCOM has to say. They have been very silent. They're the experts on the environmental part of it.
If anybody has anything new to add that has not been spoken about. Thank you, National Grid, for sitting through this.
Hello, I'm Bert Balkine. I live at 47 Appleton. Jim mentioned that the town administration recommended the board sign the NOI based upon protection of Baxter Road. Is that correct?
I'd like to defer to town manager.
That was correct. And so has the town administration provided you, the board, with any information or data and analysis saying what needs protection on Baxter Road?
It's a preventative measure in the area that is vulnerable to erosion.
So basically what we're supposed to be doing with the coastal resiliency plan is assessing properties, areas of the island that are vulnerable, and making decisions on prioritizing what we need to do with them. So I would just add that I think that we need to look island-wide. I think it's been said before, so that part has been said before. I was just curious about what analysis you guys were provided, and it doesn't sound like, it sounds like it was just a need that was expressed. It's not, there's no any hard data on that. Is that correct?
There's not any hard data, no.
Well, but there were estimates. There were estimates on, there was estimates on sewer costs and replacement. There were estimates on water costs and replacements. There's been a fair amount done. I don't know if it's all compiled in one location, but there has been a lot. We've been working on this for 3 years.
No, I understand that part.
Yeah, so.
And have you guys been doing the same thing with Mattakit and Cisco and the sewer beds, that kind of analysis? I'm just curious. Have you guys been provided that kind of information, the board?
As in regards to?
On what you said, like sewer, power?
Yeah.
We have looked quite a bit at Mattakit, yes.
Okay, great. Okay, I just wanted to, because when that was brought up by Jim, I just wanted to understand what information that was provided. So thank you very much.
Thank you. Okay, is it time to call the vote? Okay.
Yeah.
All right, all those in favor?
Aye.
Aye. All those opposed?
No.
Okay, motion passes 4-1. And I just want to be clear, that is with the September 30th. Just to go over your motion, Jim.